This is Theodore Watson, government contracts attorney, and today we're going to talk a little bit about certificate of competency determinations, and often referred to as COCs, and cover 5 main points for success when challenging agency actions or SBA certificate of competency decisions on federal projects. The COC program is applicable to all government acquisitions. Usually after bid submission, if the contracting officer determines that as a successful or as the apparent successful small business offer, your company is what we consider as non-responsible, then the contractor must refer your company to the SBA for a possible certificate of competency. After making the determination, the CO must document the basis for the non-responsibility decision, which includes but not limited to either your capability, competency, your capacity, credit, integrity, perseverance, tenacity, and limitations on subcontracting. Again, these are only some of the main issues, but it's not the only list of things that the contracting officer can consider. And after making the determination and documenting the reasons for the decision, then the agency has to send the referral to the SBA, and this is under FAR 19602. Keep in mind, the whole basis for the Certificate of Competency program is that the U.S. government can only award contracts to responsible companies. So what are the steps required before referring to the SBA? As I said earlier, when companies submit their bids, and generally you see this in an LPTA contract or lowest price technically acceptable, but it also applies to others, the agency must first decide whether your company or offers have actually complied with the solicitation requirements. That's usually the first step that in most situations where the government does make a mistake, it's usually going to be with this first step. Again, when offers submit their proposals, the first thing that the agency should be doing is to see whether the offers have actually complied with the stated solicitation requirements. And essentially, they're looking for the proposal defects. You would normally see in the RFP that failure to submit a compliant proposal could eliminate you from further consideration. So then after deciding that your proposal meets the solicitation requirements, then the agency reaches the second step of deciding whether you are a responsible contractor, i.e. Looking to see whether you're technically capable of performing, whether that may be past performance or some other factor that the agency is going to look at. One of the major cases that really spelled this out was Manus Medical LLC versus United States. This was decided at the Court of Federal Claims, and pretty much a case in point where it shows the different steps that the agency must follow before actually sending your package to the SBA for a certificate of competency decision. Responsibility actually goes to the heart of being able to perform the contract. So as I said earlier, the stated reasons are not a single list, but some of the main factors that the statute includes, but obviously the contracting officer and source selection officials can look at other things so long as it's documented and reasonable. Responsibility obviously can include, technical qualifications, past performance, etc. After the certificate of competency referral is sent to the SBA, what must the SBA do? Well, after receiving the referral, the SBA must do the following under FR 19602. There's some other things by statute, but these are some of the most important things. First, inform the small business concern of the contracting officer's determination and offer it, meaning the small business, an opportunity to apply for a certificate of competency. A concerned wishing to apply for a COC should notify the SBA area office serving that geographical area which the headquarters of the offer is located. The SBA can elect to visit the applicant's facility to review and look at various things to make a determination about its responsibility. The certificate of competency review process, just for information, is not just limited to the areas of non-responsibility cited by the contracting officer. The SBA can make its own determination on factors outside of what the contracting officer has stated in its documentation, so you might want to be aware of that. The SBA can consider denying a certificate of competency for non-responsibilities not originally cited by the contracting officers, and that's what I was referring to just now. So you want to keep those things in mind. The SBA is going to be the deciding factor. The reason for the rule is so that the source selection authority doesn't have, obviously, a lot of the decision making on technical packages and bids are, rest solely with the source selection team. What the rule does here is it takes a lot of the subjectivity out and transfers over to the SBA, and may want to call it separation of powers, if you will, but then the SBA makes its own independent decision and comes out with a ruling. Some of the tips, if you want to consider challenging these things, you want to take a look at some of the main points if you're going to successfully try to challenge or overcome a negative certificate of competency. So when submitting your bid, you should make sure that you have a compliance matrix that covers all of the express requirements of the solicitation. Why? For example, you don't want to run the risk of the contracting officer making the flawed or error of determining that your non-compliance or proposal defect somehow translates into a technical responsibility. So you want to, at least by having this compliance matrix and making sure that you've complied with all the documents and all of the what we call the preliminary requirements in your bid proposal, that would force the agency to really get to the real issues as far as responsibility. Understand that the federal agencies often confuse what is a solicitation defect with a contractor being non-responsible. So again, you have to keep the lines drawn between the two, and as you inquire or you find out the basis of the non-responsibility documentation from the agency, then we would want to look at whether it is in fact a solicitation defect or whether it is a true non-responsibility issue. Non-responsibility issues should only arise after the agency makes a determination that you have complied with the stated requirements or solicitation requirements. In fact, that is one of the issues or the items in the documentation that the contracting officer must state before sending it to the SBA. With that, you also want to watch for agency mistakes with what is a true proposal defect instead of contracting officer responsibility decisions. Agencies cannot refer a proposal for an SBA certificate of competency to cure a proposal defect. That was one of the issues that the Manus case expressly discussed in the court's ruling. Number 3, understand that the SBA has the sole legal authority for certificate of competency decisions. Therefore, the COCs are difficult to litigate in the protest. 13 CFR 125.5 also talks about, the SBA's responsibility once they get the certificate of competency referral, and it also references back to some of the FAR requirements, which also talks about the agency's responsibilities. Keep in mind that there are court decisions that suggest that you have to read both the FAR and the SBA regulations together, and they're not distinctly separate when it comes to the certificate of competency process. Fourth, if the agency has deemed your company is non-responsible, carefully look at the facts to see if the CO has made a mistake in its assessment. Again, the Manus case clearly spells out the general rules. One of the ways to successfully challenge an SBA COC is to show that the SBA did not follow its own regulations. Again, certificate of competency decisions are difficult to overcome, and especially once the SBA gets to the point where it makes a determination, they're usually pretty difficult to overcome. However, there's an exception to every rule. It's a narrow exception, but if we pay special attention to the rules, then we would know what to look for as a contractor, and then make a determination as to whether or not to get to the next step of trying to challenge. If you have questions or concerns about agency actions leading up to a certificate of competency referral to the SBA, or the SBA's certificate of competency or COC decision, feel free to give us a call. Again, I'm Theodore Watson, Watson and Associates. We're a government contracts law firm. Telephone number for us, 1-866-601-5518.